Again, I think it's the first time for me, like it's the first time for you. This whole setting of speaking to a microphone in an open space is a little bit different. Essentially, what I intend to do with you today is to consider copyright implications of training AI models on copyright-protected works. So I assume most of you use generative AI models, whether it's ChatGPT, Midjourney, Anthropic, Gemini. Now, I'm going to focus with you today on text, but the same applies whether it is text or whether it is visuals. So, for example, Midjourney is a generative AI model that generates visuals, so pictures, paintings, this sort of thing. Now, some of you probably know that in order to generate all those outputs, AI models are trained on the basis of existing works. And some of you may also know that those existing works, a large part of them is protected under copyright law. So generative AI models are trained on the basis of protected copyright law. When you have ChatGPT, ChatGPT is trained on the basis of millions of books, newspaper articles, personal blog posts, and a variety of other types of texts. And essentially what I want to look with you here today is to what extent training an AI model on the basis of protected works requires a license or requires a permission. I assume most of you are intellectual property students. Did you already cover, did you already touch upon the topic of artificial intelligence and training? Yes, no, some, yeah. I mean, for me, it would just be a little kind of useful to know, since I don't want to repeat anything that you already covered. And I don't want to take you through okay. German, did the student here already covered artificial intelligence and training in their course, to the best of your knowledge?
They cover already intellectual property.
So they know what is copyright,
yeah.
but it didn't cover necessarily AI training?
No, not yet.
Okay.
Some of them, they know already.
The
student for arbitration, but the student for innovation, they don't know yet the artificial intelligence training.
Okay. Okay, I think it's gonna be really weird, but I may actually put shades, sunglasses, rather than anything else, and that would be definitely the first lecture that I ever gave with sunglasses. Because I have a bit of sun in my face. Okay, so going back to the copyright question, to what extent can you train AI models on the basis of existing copyright protected works? Yeah, there is a bit of latency, right? I don't think it's going to happen. I can give it without slides. Okay, take 3. Let's hope that we get it this time. Right. So for this short talk, I'm going to focus on AI models that deal with text. Those models are known as transformer models. Okay? How does transformer models work? Or how do they work? They're, yeah, there's no point. I just touch it here and it goes. There's no point. I mean, that adapter, I know that it works. It worked yesterday, it worked before, it worked in Brazil, so there's nothing wrong with the adapter. And it works in London. No, but it knows the stupid territory. It's fine, because I go on and on. There's no point. German. There's no point to the slides. He stopped. And then he's going to stop again.
Let's try. I will try to help you with this.
Oh no, it's okay. I can do that. That's not a problem. You know? Yeah, that's okay. Thank you. Okay, we're going to try. We're going to try again. If not, I'm going to do it without slides. So just bear with me. So AI models that deal with text are known as transformer models, and transformer models work in the following way. They are trained on the basis of large amount of texts, and they extract statistical patterns statistically in relation to the relationship between words. So, for example, they would know that in the English language, the word is not likely to come after the word this or the word that. How do they know that? Because by ingesting billions of items of text, they learn which word is more likely to come after which word in a certain context. This is why when you prompt a generative AI model, you would ask the model to prepare something, and the output would be much better if you actually describe also the context. So you would say professional, you would say friendly, you would say informal. Those instructions and those directions inform the model that you are looking for text in a specific context, and the model knows, the model understands that in that particular context, a certain word is more likely to come after a certain word. And they know that because they have ingested, basically, models like ChatGPT, model like ChatGPT ingested the majority of English text that exists in the internet. Everything that is out there has been ingested by such models. Now, how do you know which word come after which word? We know it in a way, in the same way. We have been exposed to the language from an early age, and we know how to use certain words in a sentence in a given context. In a very abstract way, I mean, we don't mathematically extract statistical patterns from speech. But we are also, if you would like, we also learn on the basis of data. What is data? Data is experiences that we have. The experience that the ChatGPT have, or any other generative AI model, is billions of items of texts. Okay, so up until now, fine. So this is how they work in general terms. Why is it relevant to us as intellectual property lawyers? And the key question, yeah, whenever I see another tech thing coming, I'm starting to be scared. Thank you. So the key question is, to what extent an AI development company is allowed to use protected text, text that is protected under copyright law for training. I even have a clicker, thank you. We are progressing. Thank you. Okay. So the model learns relationship between words, also learns relationship between letters within a word, and also learns relationship between sentences, between certain paragraphs. And when I say learns, is by extracting statistical patterns from billions of items of texts. Now, there is a little bit of a scientific computer science type of explanation here, which I don't think we have time to get into. I have a clicker, but okay, there's a bit of latency. I was too quick to diss it. I can skip that with you, I think. Because 1, 2, 3. Yeah. Because this didn't work. I tried to go there and I'm gonna. Guys, we actually don't need, we do not need the slides. So I'm just going to continue, and I'm going to continue with you like this. I'm just going to look at what I have here, and come on, you just, yeah. I know, but I think the next time we just stop. There's no point. Is it working now? Okay, it is working now. So this is something that I just explained. Transformer models learn from vast amount of text data, absorbing patterns, grammars, and information like a child that learns how to speak by listening. Here, it's not listening. It's you're feeding this data into the model, and the model extract. Obviously, the data need to be formatted in a specific way, and the model extract the information, those statistical pattern from the. So I was asking you before, why is that relevant for us as copyright lawyers? I mean, if you listen to some people, I gave you here just one example of a guy, actually with I think millions of followers, the guy who is, and that's just one example, is a rather famous tech blogger. In his view, there's absolutely no problem whatsoever. I mean, he's not a lawyer. It shouldn't be any problem with models that are trained on the basis of protected works. He says, look, copyright law was never about controlling activities like studying. We are allowed to learn from books without asking the consent or the authority of the people who hold the copyright in the book. I mean, there's not just one problem, one main problem with this argument. And that is that when I have a book and I learn from that book, I'm not creating a copy of the book. I read the book. And it is true that reading is not regulated or not controlled by copyright law. Copyright law control, as we know, making available, making a copy, making a derivative work. When a model is learning, so to speak, or as the model is trained, all the data that is used for its training is being copied into temporary copies. So the actual training process includes the preparation of temporary copies of each and every data item. Each and every blog post that was used, each and every newspaper article, each and every book, all of those items that are used to train an AI model are being copied only temporarily, because that's the way the technology works. So you have a temporary copy that is made in order for the statistical pattern and the statistical data to be extracted from those works, and then afterwards this copy is being destroyed. It's not being kept, but a copy is created. And if a copy is created, then copyright law is engaged. And that is quite different from the way you and me read a book. We don't create a temporary copy. Now, if copyright law is engaged, then the next question is whether copyright law includes an exception or an exclusion for the preparation of such copies. We know that not every copy is being caught under copyright law. We know that not every copy necessarily results in an infringement. There are certain copies that are excused from infringement under certain circumstances. I'm sure that you have a list of copyright exceptions here in Colombia, in Colombian copyright law. And under those exceptions, even if a copy does take place or occurs, infringement does not follow because it is exempted from, it is exempted for the purposes of infringement. And therefore the question is whether the training of AI and the preparation of those temporary copies is also exempted or should be exempted from copyright protection. Now let me give you some examples to what happened if you prompt a model in a specific way. Now, when you use ChatGPT, and I'm sure some of you do, just for fun, right? If you use ChatGPT, you prompt the model and you ask ChatGPT to prepare this for you, to summarize that for you. Fine. But ChatGPT and any other generative AI models can do more than that. Here is an example from the new... Here is not an example. Here is an example from the evidence that was brought before the court in the lawsuit that was filed by the New York Times about a year and a half ago against OpenAI and Microsoft. Microsoft because it owns a share in OpenAI. Now, on the right-hand side, you have the original article of the New York Times. This was one of the billions of items that was used to train ChatGPT. On the left, you have an output from ChatGPT that was prompted in a very specific way by data scientists and AI experts that were acting on behalf of New York Times. If you have a look at the text, you would see that it is almost a near verbatim copy. So ChatGPT, this is known in the industry as data extraction attacks. Any generative AI model, at least to the best of my knowledge, if it is prompted in the right way, can actually generate or output verbatim or near verbatim copies of the data that was used to train it. And this is not the only piece of evidence that the New York Times actually brought. This is just one. There are numerous examples of that nature. So you can see that the statistical patterns that are extracted by the model can actually be used to generate verbatim copies of the data that was used to train it. I'm going to skip retention. I'm going to deal with another argument. If you ask AI companies, why don't you ask permission? They will tell you, because we don't infringe. How come you don't infringe? One of the arguments that they would put forward is that activities like this should be exempted from copyright law. For example, in the same way that Google Library, the scanning of those millions of books by Google without permission was also exempted from copyright infringement under US copyright law. Google afterwards entered various licensing agreements. But essentially, what Google did in the Google Books project and what AI companies are doing is quite different. I don't know if do you cover US copyright law in your courses here? Okay. So you're probably familiar with the fair use defense under US copyright law. And this particular, in the Google Books case, Google was excused from copyright protection because it was held that, or it was found that that preparing the Google library by scanning all those books amounts to fair use. What the court found in the Google Books case that the only thing that Google was doing was indexing. It was scanning all those books in order to enable people to know which phrase sits in which part of which book. And that's it. If you go today and you go online and you look for a book on the Google library, you won't be able to read the whole book. You won't be able to read a whole chapter. You probably won't be able to read more than one page at the most, if at all. You just be able, in most cases, to read a paragraph or two paragraphs, and that's what tells you, it gives you the context. It tells you that, okay, this stuff that I'm interested in is in this book and does exist in this chapter, but at least I know how it works for me. In the majority of cases, when I see that this is the case, I know that I should go to the library or go elsewhere and actually look for the full book in order to read what I'm interested in. What the court in the Google Books termed as indexing. What AI company is doing is not really indexing. It's not even close to that. An AI development process and an AI training does the following. Large amount of text are ingested. Statistical patterns are extracted from the full text to the extent that today you can, if you prompt the model properly, as you could see, actually generate an output that amount to a full article, which is either a verbatim copy or a near verbatim copy of the original article that was used to train the model. The same applies for books and for other items of text. So this is not indexing. This is something that enables you, if you know what you're doing, to generate full copies or near full identical copies of the text that was used for training. I'm going to by the way, I showed you before text. This is just an example of image, right? So this is, well, Super Mario needs a little introduction. But you have the original Mario here, and here you have what Midjourney generates in relation to a prompt that says video game Italian plumber. So you can see that this is not indexing. What you have here is enough information is taken from the original content, it doesn't matter if it's statistical, it doesn't matter that it's represented numerically, but it is enough or sufficient information that enables the model, if prompt correctly or prompt in a particular way, to generate a verbatim or a near verbatim copy. So if you look at them, they are not exactly identical. I mean, you can't see here with clarity because the screen is very large. But with a normal screen, you would see that there are differences in the hat, and there are differences in the script that appears on the hat, and some other differences. But that's about it. Can't breathe next to it, huh? So, do we have, there it is, we talked about that. Now, there are a variety of cases out there. In the United States at present, there are more than 40 cases. 40 cases before various courts in the United States that relate to copyright infringement regarding the training of AI models on the basis of copyright-protected content. Very recently, just a month ago, 12 cases were actually consolidated in the District of New York. So that's going to make a big difference, because you're going to have 12 cases being heard before one judge in one set of proceedings. So in my view, at least, what we're going to see is the center of gravity in those cases actually being formed in the First Circuit. So the First Circuit is the federal circuit that is responsible for federal cases within the region of New York. But there are also cases that are currently being heard on the West Coast, specifically California. And the two cases that I put here, Bart's and Anthropic and Kadri versus Meta, were actually decided this June. So both cases come from the Northern District of California, so San Francisco. And in both cases, when authors brought an action against AI companies and claimed copyright infringement in relation to copies that are created during the training process, in both cases, who won? The AI company won. On the basis of fair use. In both cases, the court said the preparation of temporary copies during the training process amounts to fair use. Why? A key term for that purpose under US jurisprudence is that the copying or the use by the defendant was transformative. Now, if you have done, and I understand that you have done fair use, or you have looked at fair use, you probably know what transformative means. It means that the use by the defendant was of a very different nature. The copies that was prepared was for different purpose, delivering a different function, and therefore it's transformative. The second of those cases, right, they were decided 2 days, one after the other, in the same court, but different judges. So I write it here. One was Justice Alsop, and the other is Chabaria. And actually in the second one, in the case of Chabaria, Judge Vincent Chabaria, he was prepared to consider fair use, but he said that in order to consider fair use seriously, he would like the plaintiff to produce evidence that there was market harm. So show me that the training of AI models on the basis of protected copyrighted works harms your market for, in that particular case, for creative works. Show me, for example, that when it is trained on the basis of your works, those AI models afterwards saturate the market with works of their own, and that is harmful for your market for that purpose. Now, I actually think that such evidence could have been produced, or may have been produced, but the lawyer for the defendant failed to, the lawyer for the plaintiffs failed to do that. Actually, the judge criticized personally the lawyers for the plaintiff by saying, I have asked in advance for evidence of market harm. If I would have seen evidence for market harm, I could have decided this case differently. But no such evidence was brought before me whatsoever, and therefore, on the basis of the facts before me, I am bound to find that no infringement took place, and it is fair use. So it was transformative, but if you would have balanced the fact that it's transformative by the fact that it is harmful for your market, then I could have found otherwise, or I could have found differently. So this is how the US deals with it. You know how fair use plays out. I understand that you've done some work on fair use. It's a very specific, fact-specific and fact-dependent type of copyright exception. And you're going to have various decisions in federal courts around the country. And that is at the first instance. Without a doubt, we're going to have appeals. And then at a certain point, I will be most surprised if one of those appeals do not reach the Supreme Court. You know, in the United States, like in most other jurisdictions, the highest instance in the land you cannot appeal to the highest instance in the land automatically. It is upon leave. You need to get permission in order to do that, and they only grant permission in important cases of significance, when there are important points of law to adjudicate. And I will be extremely surprised if they would not find that there is an important point of law when one of those decisions on training of AI models on the basis of protected works does not reach the Supreme Court. But that's the way it is in the United States. You have at the beginning some confusion, and then some court decisions, and around those court decisions, standards start to materialize. The process itself probably takes a good few years, during which it's a bit of a Wild West. It's each for its own. You know, technology companies always worked on the basis, and that's always the case. And I guess when you guys go to private practice and a client asks for advice from you, many times this is also the advice that we lawyers give. Better say sorry than ask permission in advance. So go for it. And if it's infringement, you know, you worry about it in the end of the day. But by that time, you have done various things. You have established various either patterns or facts on the ground, and then retrospectively, you may have to pay some damages. Some kind of a compromise need to be reached. And technology companies have always done that. Right? Google created the online library, and then afterwards try to defend it in court. Google creates, or any other search engine creates copies, small copies of images, thumbnail images, and afterwards says sorry or not sorry and fight for it in court in relation to fair use. So in the end of the day, the US has always been like this. Europe is quite different. And in Europe, we actually have legislation that deals with this issue. We have two provisions, Article 3 and Article 4, and they regulate the use of protected works for the purpose of training AI models. Now, this is legislation that dates back to 2019, and it has to do generally with text and data mining. But recently, our AI Act made it clear that those two provisions also apply to AI training. Now, what those provisions say is as follows. And I'm just going to put that for a second. Article 3 tells you that cultural heritage institution, you may train your model on the basis of copyright-protected works without asking anyone's permission. And even if you know, and they made statements to that effect, that they don't like it, and they are not interested, and they are not happy with you doing that, tough. You may nevertheless go ahead and do that. This is if you are not-for-profit research organization or a cultural heritage institution, museum, you know, some kind of public archives. So far, so good. I mean, still gives rise to various questions. What do we mean by not-for-profit and so on? But interestingly, Article 4 takes the same principle of go ahead and train, don't ask for permission, and actually transfers it also to a commercial context. So Article 4 tells us that even if you are for-profit company, for-profit organization, you may nevertheless train your AI model. So this is your OpenAIs, Geminis, and so on. You may nevertheless train your AI model on the basis of protected works without asking permission, but here there is one difference. Unless what? Unless the copyright holder in those works reserve his or her right. What do we mean by reserve right? Reserve his right is opted out of this arrangement. Now, how do you opt out? How do you tell the world, how do you tell AI companies that you are not interested in having your works being used for training? The provision or our legislation says by using a machine-readable format. So those of you who are familiar with how the internet works, and for example, if you don't want your work, for example, there are certain websites that would not appear in search results. Why is that? Because those websites embed on those web pages a few invisible lines of code that basically tell internet crawlers not to index their work. That's a machine-readable format that tells an internet crawler, stop, not here. The same principle applies here. Embed in your work, embed in your online content, and opt out. So an instruction for an internet crawler not to use your content for training. So opt out, but even this is, people would argue, rather generous to AI companies, because if you think about copyright law is not about an opt-out arrangement. Copyright law is actually about an opt-in, sort of. What is copyright? Copyright is as follows. This is my property. You may not do anything with it that involves infringement unless I give you permission to do so. What is permission? License. Our legislation takes this principle and turns it on its head. You're basically saying, here is my property. Unfortunately, you can do what you want with it for the purpose of training, unless I tell you no, in advance and in a specific way. That's an opt-out. So the idea here was to create some kind of a balance. You want to create an environment which is friendly for AI companies because you want to attract AI industry to your jurisdiction, on the one hand, but on the other hand, you don't want to give everything away. For instance, Japan. So Japan has a very, very flexible, a very relaxed, a very generous regime for AI companies. In Japan, you may use protected content for training your model, whether it is for profit or not for profit. There is no opt-out in Japan. But the EU does one last thing here, which is also very interesting and interesting also to you as Colombian lawyers, because it has an international impact. So I don't know how many people here do privacy law and know what the GDPR is. But you would see that I have no idea how actually, I'm getting rain on me and there is a roof. It's a wonder. Because of from the side. Right, okay. So the GDPR is a set of rules that have to do with privacy, which lawyers that deal with privacy all over the world are familiar with. Why? Because when the EU created the GDPR rules, it created it in such a way that even if you operate abroad, even if you process information abroad as outside the EU, even if you do all those things outside the EU, the minute you offer a service related to that in the EU, and I'm oversimplifying things, EU rules apply. And what they did here in copyright law, in relation to copyright law, is exactly the same. Essentially, what the EU AI Act does is to include an extraterritorial provision. And what this provision says is as follows. We don't care where the copyright relevant acts took place. As long as you offer the model, the AI model, to the EU or in the EU, our copyright rules apply. So if you think, for example, that you can take your model, let's say, to Japan, just as an example, train it in Japan, create all those temporary copies in Japan. Technically, when you do that, the only rule that should apply is the Japanese rule. But the EU says, no, we don't care where you did those copyright relevant acts. Wherever you did it on the moon. The minute you take that model that was based on those acts and offer it in the EU, our copyright rules apply. In other words, you play in our court, you play by our rules. So they created this regime of Article 3 and Article 4 and then included an extraterritorial provision to make sure that you will not be able to circumvent it and to go to some AI-friendly jurisdiction and do your training over there. The EU also included, and that's an important provision, a provision which provides that each AI model operator is required to maintain detailed summaries of the data that was used to train its models. That means that you are under a positive obligation as an AI provider to maintain those summaries. Now, why is that relevant? It's relevant because if I'm a right holder and I suspect that your model was trained on the basis of my data, I can go to you and say, can I please see the summaries of your training data? Because I want to see if my content was used for that purpose. And I will know, for example, let's say that I put an opt-out or I included an opt-out in my model, and I nevertheless see that you trained your AI model on the basis of my content, I can come and say, well, you are not in compliance with Article 4, and you have to pay me, and you have or you have to stop to doing what you are doing, and so on and so forth. The UK, we actually have only something that is equivalent to Article 3 right now, but the UK is changing its laws as we speak. So there was a government consultation, there are a lot of debates in Parliament. I took part in some of those processes myself and provided advice. It is work in progress, and I suspect that within the next few months, we're going to have a set of recommendations by the UK Intellectual Property Office to the government in relation to the introduction of new legislation which, amongst other things, would regulate the use of copyright-protected content as training data for AI models. So these are the initiatives. Japan I've mentioned to you. I talked about the jurisdictional aspect, which is the extraterritorial. One last thing. If you ask me where do I think that we are going, we're starting to see more and more licensing arrangements out there. The same OpenAI that was sued by the New York Times has a licensing arrangement with AP, with Associated Press, has a licensing arrangement with Axel Springer, the big German media conglomerate. Collecting societies. Did you do CMOs already? Collecting management organization in your copyright classes? But perhaps with some of the students, yes, some of the students no, because I can see some nod, some to that direction, some to the other. But a collecting management organization is an organization that administers rights collectively, let's say, for all the visual artists in a particular jurisdiction, collectively collects royalties and then allocates the royalties. So it's just about transaction cost. It's much more efficient to have one-stop shop in one jurisdiction to which you come in order to get a blanket license and you pay royalties only to one and so on. So there are arguments that AI companies should actually pay royalties to new collecting societies, collecting management organizations that would be established. I think that we have a long way to go here. Even if we do agree that licensing fees or royalties should be paid, there are still a lot of challenges. I'm not talking about bilateral arrangement. Of course, the New York Times can go to Gemini and say, look, I'm sitting on an archive, a digital archive going all the way to the 20s of 180,000 newspaper articles. If you want that, that's what you have to pay. Fine, this can always happen. This is where you have bilateral agreement, and that is, it doesn't present any particular issue. It's just a question of price, of course. But when you talk about, there are some data sets out there. For example, Leon. Leon is a data set for visuals. It's a German operator of data set for visual that includes more than 5 billion items, 5 billion photos and paintings, right? When that is the case, how do you collect royalties, and how do you allocate royalties to whom? So there are a lot of challenges here. There are also suggestions and ideas. For example, don't pay royalties at the point of entry. Don't pay royalties at the point of training. Pay royalties only for output. So like you used to have in certain countries, say photocopying machines, where you would pay a very small amount for every photocopy. It's basically a copying, it's a copying levy. Those copying apparatuses would be bound by. The same would be here. You would be able to get a log. An AI company would tell you, okay, in Colombia, ChatGPT in the month of August generated, I don't know, 10 million outputs, textual outputs. Fantastic. ChatGPT would pay according to that. There would be a price per output because you would say that each and every output is, in a way, a result of all the textual training material that was used. So let's say you would say that for 10 million output, they have to pay 100 million, 1 billion pesos. Okay, so this is helpful in the sense that this is how you collect and this is how you calculate how much to collect. So that's fine. Now, how do you allocate it and to who do you give it? That's a question, a fair question on its own. You're going to give it to whom? To everyone that ever generated, to anyone that ever generated content in Colombia or beyond Colombia and put it online. It's not practical. It makes no sense. Nobody's going to get anything. He's going to get a penny, and the cost of administrating this system would be much, much larger than any benefit. So there are various suggestions out there. For example, of course, nobody's going to get me and you and all of us that put some blogs out there and perhaps they were used in order to train an AI models. We are not going to see a penny out of it. But if we say, okay, this has to do with text, let's say journalism, literature, and so on, this pot of money would be used by a collecting society in order to advance certain purposes, certain objectives, for example, supporting young authors, supporting young journalists, this sort of thing. So, and again, this is just, all of those things are just swirling out there. These are all suggestions people are thinking because it's a new reality for us. And it's a new set of circumstances that we need to accommodate, and therefore we need to consider new ideas rather than necessarily going to those old ideas of collecting management societies as we have in music, where the situation is completely different. So, I mean, the Chinese have a saying, you live in interesting times. So we do live in interesting times, and things are happening as we speak. And thank you very much for bearing the cold and the wind and the technological glitches and all the others during this talk. So thanks, guys. And if you have any questions, now, in public, in private, to come after. So, yeah, feel free. There is, okay. How we do it with the microphone?
Thank you very much, Professor Shemtov, for your very thoughtful and provoking conference. I would like to ask you, what should be your forecast for the New York Times B ChatGPT lawsuit? Do you think that New York Times will prevail in this case? Thank you.
Okay, so that's an interesting question, because when the lawsuit was actually filed, I gave an interview 3 days afterwards to the CNN business program on the lawsuit itself, and I said that I think that this lawsuit is a little bit different, not because the factual matrix is necessarily completely different. The New York Times did its homework really, really well and came very, very prepared. They didn't spare any resources in preparing. They knew that they're going to go for a long one here, and they threw all the necessary resources at this lawsuit. And therefore, if you look at the lawsuit, it's not about just copyright infringement in relation to the training per se. They file a copyright lawsuit, they file a lawsuit in relation to copyright infringement resulting from the training. They file a copyright lawsuit in relation to copyright infringement relating to the output. I mean, the output that we saw, the output is copyright infringement. This is an almost verbatim copy of the original article. So they have it for that, and even there they split it into two. And they said, look, there's copyright infringement in relation to the output. Now, they knew that one of the arguments that AI companies are throwing at plaintiffs in that respect is nothing to do with us, mate. We have nothing to do with that. This is the user that prompted the model in a particular way in order to generate the copyright infringing a copy of your article. Go after the user. That has nothing to do with me. And therefore, within their lawsuit, they also included another element. So first of all, you are liable for what we call in the States for direct infringement, what we call in the United Kingdom primary infringement. But you are also liable in case it is the user who is the primary infringer. In case it is the user who is the direct infringer, you are liable for indirect infringement or secondary infringement. Right? Secondary infringer is the one that facilitates infringement by the primary infringer. So they threw all of that. They also threw state unfair competition laws at them. Basically, as we say, they threw everything, including the kitchen sink, and at the defendant. And I do not see OpenAI getting out of that unscathed. I actually think that we may have a settlement at a certain point because, again, those things are confidential. But the rumor, I sound like a gossip journalist, but the rumor, I think it's substantiated rumor, is that prior to the lawsuit by New York Times, there were negotiations between the New York Times and OpenAI in relation to licensing. Those negotiations did not mature. So we may very well be in a case where we will never get a judgment. It would continue, and when both sides realize where it's going, they're going to reach a settlement on the basis of the leverage that they think as to how the proceedings actually, progressing. So that's my guess.
Thank you very much. If I may, a second question. Are you aware about any case regarding the application of the digital copyright directive in the European Union?
Yeah. Yes, there is a case actually, but it's not a decided case. So there are two cases which are relevant in the United. German, the microphone. I think the guy at the back. So one case was decided recently by the District Court of Hamburg, and that was a case of a guy named Boris Kneschke, who is a photographer, a German photographer, and Kneschke sued Leon. Actually, he didn't sue an AI company, he sued the dataset provider. Leon is one of the largest dataset providers in the world. OpenAI, to the best of my knowledge, is using Leon. As I said, about 5 billion items. A lot of other AI companies use Leon. The problem for Kneschke was that Leon is a not-for-profit dataset provider. It is about, so Leon's objectives are the enhancement and the furthering of research. And for that purpose, it collects data, it formats data in a specific way to make it easier for tech companies to actually access the data and extract information from that data. So Kneschke had a problem there, and therefore Kneschke had to face also Article 3 for that purpose. But the case which I think would make the biggest difference, and I said would make because it's pending, it's a case that is called Like Company versus Google. That was actually filed just a couple of months ago. Sorry, not filed. That was referred by the Hungarian court to the Court of Justice of the European Union. And without going too much into detail, what you have there is a replication of the New York Times scenario. You have a newspaper, a Hungarian newspaper, that claims that that Google has used its articles in order to train its chatbots. And the Court of Justice for the European Union is going to, and like the New York Times, they also had their own AI experts that prompted Google's model in such a way that the output was a verbatim copy of their articles. So you're going to have, the Court of Justice for the European Union is going to decide there on the operation of Article 3 and Article 4. The Court of Justice of the European Union is going to decide there on any infringement resulting from outputs, so identical outputs. I suspect that we're going to have probably about a year for this one. And the Court of Justice for the European Union, once it speaks, it becomes law, right? So those judgments have to be applied, whether national courts like it or not, have to be applied by national courts. Yeah.
Yeah. Good afternoon, Professor Shemtov. I just wanted to say thank you for such a brilliant conference.
Thanks.
It's a privilege to have you here. I just wanted to ask you about the possibility, like your thoughts on the possibility of eventually making patents out of prompts. Since you mentioned AI training, like specific, those deep learning machines through specific prompts and giving them data in order to train them. So I just wanted to ask you about possibly making patents out of such prompts that are used.
Making who have some prompts, such prompts?
Making patents.
Patents?
Yes, sir.
From the prompts themselves?
Yes, sir.
I mean, the prompt itself, actually, there's an interesting question. Some prompts, whether prompts themselves can be protected under copyright law. Some prompts, I think, could be, when they're long, original, and so on. But do you use ChatGPT or you don't want to say? If you do.
I do, sir.
So if you go to ChatGPT and you go to setting, you would see that one of the options that are available to you, one of the options that is available to you is to ask ChatGPT not to use your prompts and your inputs for the purposes of training the model. So this is for privacy purposes. You don't want information which is embedded in your prompts to be used by the model to be trained, so to optimize the operation of the model, and therefore potentially afterwards to be extracted by others. So the answer is, of course, our prompts, unless you order the model otherwise, our prompts are used in most cases by the models. And when I say used for training purposes, so statistical patterns are extracted from them as well. That applies to your prompts, that applies to documents that you actually upload to the model and ask the model to manipulate in one way or another. Of course, they extract statistical patterns from all of those items, including our prompts, unless you ask them not to do so. So, for example, with me, it's my default option. I don't want ChatGPT, and Gemini gives you the same option to actually use it. I think it is available only for paid subscriptions, right? Because when it's not paid, why would they offer it for you for free? They need to get something, right? So you know the saying, when the product is for free, you are the product. So, yeah, exactly.
Thank you very much, sir.
Yeah.
I have another question, sir. It's a bit related to the previous question. I just wanted to,
Sure.
We are soon to be lawyers, so we're going to be dealing with private information and, many legal cases, some privileged information which we cannot discuss publicly, for example. So I just wanted to know if you know a way in which we can guarantee
I know exactly where you're going with that. So the answer is, yeah. First of all, there are, I don't know here, but there is a good number of AI tools that lawyers and law firms use today, especially IP lawyers. So I think the IP profession is particularly suitable for the deployment of AI tools. If you think about it, so I would say that you have in the legal profession AI tools that are effective at 3 domains. One is text, pure text. So summaries, document review, all of those things, right? So preparing summaries on the basis of a large volume of content, for example. The other is what you would call, so that's generative AI. Then you have predictive AI. So this is when you have today AI models that process vast amount of case law in order to find fact patterns that are similar to the dispute that you are dealing with now, and then give you an estimation as to the likely outcome of this dispute. So that's fantastic for you as a lawyer, because you know where this case is probably going on the basis of similar fact patterns from the past. So that would enable you to advise the client, to reach settlement-related decisions, and so on. And thirdly, especially for IP, it's image recognition, so AI image recognition systems. So for example, this is particularly useful today within the domain of trademark law, so comparing marks. Comparing marks, 2-dimensional, and today you also have systems that are good with 3-dimensional. So that's good for, by the way, IP offices, but also good for monitoring infringement. You have today AI systems that monitor the web. Anytime that anything similar to your mark appears out there, you get an alert within no time. And then you can jump at the platform and say, send a cease and desist letter and tell them to get rid of that. So all of those things are already there. And to my knowledge, all of those tools enable you, but I mean, you have different licensing schemes, and when you are prepared, I think sometimes to pay more, then the option of not having your content training a model that can actually be used by competitors of yours, other law firms, right? So what you are doing is contributing also to their skills. Well, obviously you don't want that. A law firm would not want that. They do not want to, for example, upload their contractual clauses and ask an AI, for example, AI tool like that law firms use, like Harvey, something like that. They don't want that afterwards to become a standard, and therefore when other firms use the same AI tools, this clause is already there in that particular context, so then you're losing your competitive advantage. So you can have the option of excluding your content from being used for that purpose, yeah, in a lot of those cases.
Thank you very much, Professor.
Pleasure.
Good afternoon, Professor. Well, I would like to echo the sentiments of my colleague or fellow student.
Thank you.
Thank you for coming. It's truly a privilege. I would like to ask, I think there was a question in your presentation about like what happens to the artists that uploaded anything before the opt-out rule.
Right.
And specifically, I believe there was a case made about Adobe,
Yeah?
where they, in their EULA, for example, Photoshop, they basically had a clause that said that they could train their AI models on anything that was produced with their software. So, especially when it comes to the little designers, artists, the people who cannot afford maybe a very big lawyer, what happens to them? Like, are they protected? Can they do anything about it?
Okay, so that's a good question, and the short answer is that those provisions do not have a retrospective effect. So anything that happened up to that point, effectively, anything that happened up to that point should be regulated under the laws as existed up to that point. Now, what existed up to that point? You didn't have any particular exception, and therefore the traditional copyright law applies. And here, traditional copyright law is Article 3 and Article 4 go back to 2019. Right? Because remember, this is not the AI Act. As I said, the AI Act only made it clear that Article 3 and Article 4 apply to AI training. By that point, so about 2019, I don't have a map of that, so I don't know what was trained until 2019. But generative AI at that point was very, very different from what we have now. The appetite of generative AI as we have today and as we had, I mean, ChatGPT, what is it? 2022, that's it. I mean, it looks like it's been there for ages, but it's fairly recent. Beforehand, models did not work like that. You had very specific, narrow models. So for example, if you were in the business of visual arts, you would train your model, say, and you are in the business of producing, you had the project of producing a portrait, right? So I'm thinking about a particular case. It's not a case. It was a story. It was a famous story at the time because you had a French trio that trained their model on the basis of portraits within the span of, I think, 350 years, and produced what was then sold afterwards in Sotheby's as the first portrait to ever been produced by generative AI, of an imaginary person called Edmond de Bellamy. This is the name that they gave to this guy. And it was estimated at $9,000. It sold for $4,308. So it was sold almost $500,000. My point is that at those points, the AI as it existed was trained on a very, very specific set for a very, very specific objective. What we started to see later was, in most cases, after those provisions came into play. And what I think is very interesting in your particular context is nobody knew also at that point, nobody opted out. Nobody put any machine readable. The question is, okay, now the European Commission is actually working on a standardized form of opt-out. So it would be clear all over the European Union to any person who actually has content how to opt out. And you can say, okay, I opt out now because now things are clear. What happened to all the stuff that they took before opting out was clear and was available? And the answer is nothing. You didn't opt out, tough luck. And if you think about it, that if you just take this point of time today, everything that exists out there on the internet today was already taken. And people didn't opt out. So I think the opt-out thing would be particularly relevant for future works, future content, because those models need all the time more and more, they are never satisfied. They need more content in order to be better and better and better. And it's competition between various model providers. They want their model to be better than the other and so on. So there's still going to be a market for that purpose, but that's only in the EU. Of course, in the US, it's all about fair use. So if it is found that it was not fair use, so the New York Times is going after OpenAI in relation to its full archive, or almost full archive. That's a lot of items. Now, in the US, they also have, but I'm digressing, they also have this thing which is called statutory damages. Statutory damages, if you don't want to go to calculate damages on the basis of the actual damage, you can go, and if I'm not mistaken, it's $150,000 for willful damage, for willful infringement per instance. And even if it is not willful, so you didn't know and you had no reason to believe that you are infringing, it is $30,000 per instance. So yeah, I mean, they're throwing everything that they can, and then of course you settle in the end. It's never what it goes on, what shows on the paper.
Thank you very much.
Cheers.
So there is one more question. One of the students is quite shy for giving the question, but the question is, if there is like a collective license for the use of the artificial intelligence in the favor of the authors in Europe, if you think that this model should be implemented globally, in the case that obviously the European Union are taking.
Yeah, because if you think about it, copyright law is global in the sense that you can be a Colombian author, right? If a model has been trained, and remember, it doesn't have to be trained in the EU for that purpose. If a model has been trained anywhere in the world on your work, you own copyright. Your copyright exists also in the EU. I mean, if you're a Colombian author, somebody makes use of your work in the EU, your copyright bites. So for that purpose, yeah, the fact that you are outside the EU, you are not part of an EU type of a network should be relevant. So you should still be entitled for any licensing fees. But again, single authors, I find that difficult. I mean, I don't think that it's not fair or not right. I just think that in terms of transaction costs, I mean, how are you going to administer a system where models have now been trained on billions of content items? Who's going to, and probably millions and millions and millions of authors. How do you calculate that? And don't forget, I mean, if you want to get technical, how do you calculate royalties in the case of music, right? Collecting societies. So let's say that you run a restaurant or a bar. You need to give the collecting society your playlist. They have an algorithm that crunches it, so they would know, say, for example, Taylor Swift needs to be paid much more than a certain indie artist, because the indie artist may have been played once by you, but Taylor Swift has been played, I don't know, 60 times in a month time. So there are ways in which, but if something has been ingested, how do you calculate how much time it has been used? It's not the same, right? What do you go by? So I think that one of the things that could emerge is putting all the money into a single pot, and that pot being used not in order to pay authors, but in order to advance certain objectives that has to do with literature, journalism, music, whichever kind of model you are dealing with. I think this is a sensible, or as I said, your New York Times or your Washington Post or your biggest newspaper here can actually enter into a bilateral licensing agreement, and they don't need any society, and they say, you want my content, you want my thousands or tens of thousands or hundreds of thousands of items, that's what you're going to pay, and they negotiate on that basis. So yeah.
Okay. Thank you very much for everything, for this amazing conference, and as you see, the students are really interested in the topic, and I don't know, un aplauso para.
Thank you, guys.
I invite you to take a picture with the professor here in front, because we are not that much.